All right, ladies and gentlemen. I'm Michael Scharf. I'm co-dean of the law school, and it is my great privilege today to welcome you to our program, Police Reform, Why Respect for Difference Matters. Freddie Gray in Baltimore, Walter Scott in South Carolina, Tamir Rice here in Cleveland, Kay Gurley in Brooklyn, Michael Brown in Ferguson, Eric Garner in New York City. Each of these was a high-profile incident in which an African American was killed, usually by white police officers, in the past 2 years. These cases have triggered protests and riots in their cities and around the country. But most importantly, they have sparked a national conversation on the importance of police reform. This afternoon's panel constitutes our law school's annual diversity lecture, which focus on significant issues of diversity and inclusiveness in the practice of law. At Case Western, we believe that respect for diversity is central to the practice of law, and we practice what we preach. So this year, co-dean Jessica Berg and I have appointed a highly respected professor and faculty leader, Rukiya Yerby, to be the newly created position of Associate Dean for Diversity and Inclusion. We are the first law school in the country to have created this position. This year, we've also brought in experts to conduct workshops on diversity and inclusion for our faculty, for our staff, and for our students. And we've even established 2 gender-neutral bathrooms on the first floor in sensitivity to our transgendered students. Our faculty members have appeared frequently in the media on the issue of police reform in the wake of the incidents that I described above. Professor Benza, for example, recently did a faculty view at CWRU, which is our new faculty video podcast series, about the Tamir Rice case, and you guys can click on our website and see that if you'd like. We are especially proud that 2 members of our community are playing a significant role in police reform here in Cleveland. 3L student Amanda King is one of 13 members of the court-mandated Community Policy Commission, created to strengthen the relationship between the Cleveland Police Department and the citizens that it serves. And visiting Professor Ayesha Hardaway, who I am very happy to report was unanimously voted a tenure-track position here a few weeks ago, is a member of the monitoring team. Well, we'll do that. So she is a member of the monitoring team that is part of the Department of Justice consent decree for Cleveland. And Ayesha is one of our distinguished panelists today. So we started a little bit later because we were waiting for our last panelist who will be arriving any minute now. But I think it's a good time for me to turn things over to Associate Dean Yerby, and she'll introduce the panel. Thank you all for being with us today.
Thank you, and thank you for coming to this year's diversity lecture. I am excited about the panel. We have worked closely with members of the faculty, but particularly Professor Ayesha Hardaway, to address this timely issue in Cleveland. And I do just want to thank Dr. Rhonda Williams, who also is on the panel to reform the Cleveland police. So without further ado, I'm going to introduce the panelists. We do have one panelist who is still making his way here, and so we're going to change the event a little bit. We were going to start with the background of what happened in Cleveland prior to the current consent decree, but we're just going to go right into that, and then we will go into the history. So without further ado, let me introduce the panel. We have Daniel Chaplin, who in 1983 graduated from Cleveland Marshall College of Law, Cleveland State University. He is a solo practitioner whose practice includes preserving and rehabilitating homes and businesses in that area. From 1991 to 1993, he represented Edward Henderson, a mentally ill man, in a police matter, and since then has focused his law practice on police interactions with those who are mentally ill and the criminalization of mental illness and poverty. Beside him, we have Professor Ayesha Bell Hardaway. She is a visiting assistant professor in the Milton A. Kramer Law Clinic, where she supervises students as they represent clients in disability, guardianship, emergency mental health, commitment, housing, and employment-related cases. Prior to joining the law school faculty, she practiced in the litigation department at Tucker Ellis, LLP, and before her time there, she was an assistant prosecuting attorney for Cuyahoga County and handled a variety of criminal matters, including juvenile delinquencies and general felonies. Mike Nelson, who will be here shortly, is an advocate for social justice and economic justice. In 1989, he graduated from Case Western Reserve School of Law. His civic commitment has been recognized by 2 governors of the state of Ohio, who appointed him to successive stints on the Central State University Board of Trustees, and by 2 Cleveland mayors who appointed him to the Northeast Ohio Regional Sewer District and the Civil Service Commission of the City of Cleveland. In October of 2015, he was elected the president of the Cleveland branch of the National Association for the Advancement of Colored People. And finally, Maya Simek, I'm sorry, how do you say it? Simek, is the Director of Programming at the LGTB Community Center for Greater Cleveland and founder staff attorney of the Community Lawyer Program at the Nueve Luz Urban Resource Center, and you'll have to correct me because I'm sure I got that wrong too, sorry. She also works as an adjunct clinical law professor in the Community Advocacy Clinic at Cleveland Marshall College of Law. She is licensed to practice in Ohio and California and is a licensed independent social worker in Ohio. She holds a JD from Cleveland Marshall College of Law, a master's of social service administration from Case Western School of Applied Social Sciences, and a Bachelor of Science in Psychology from John Carroll University. And so as I step back, because I am also going to be moderating the panel, I would like to start this conversation just about the current consent decree. And I'm going to turn it over to Professor Hardaway.
So thank you guys for joining us. And indulging us with a little bit of a late start. This probably is maybe the right place to start, right? So the consent decree, what is it? How did we get here? And what do we anticipate happening? As Dean Scharf indicated, I am a member of the monitoring team that is charged with overseeing the implementation of the consent decree. What is the consent decree? It is an agreement between the City of Cleveland and the Department of Justice that lays out the avenues and the methods of police reform for the City of Cleveland's police department. Specifically, the consent decree addresses certain issues like community policing, the need for bias-free policing, the use of force policies that the police department use, whether they're less than lethal force or lethal force, what the equipment and the resource mechanisms are that the department has, as well as training, hiring, and promotion. And so it's a little bit of a hefty document. Many of you have probably seen it, and with multiple paragraphs. But the monitoring team is charged with making sure that each and every part of the consent decree actually takes place. And it is right now budgeted for a 5-year stint. What that means is that maybe we know that at least it will take 5 years. That's what it means. We know that at least it will take 5 years. And what I've been saying to people that I talk with around our community is that it is definitely a marathon and not a sprint, right? As tragic as some of the incidents have been that have happened in our community, and we all want to see change and see change now, it's going to take a long time because it's taken a while for us to get to this point. So how is it different than perhaps, why, thank you, sir. Come on down. Yeah, that would be bad.
Michael Nelson.
Yeah. Maybe he's a rock star. Thank you. So what does the monitor, or what does it mean to be the monitor? The monitor is the agent of the chief judge for the Northern District of Ohio, Solomon Oliver. And the monitor's name is Matthew Barge. He has a 17-member team, of which I am included. It seems to be growing by the day. And that team is charged as subject matter experts to make sure that all of the various areas that I identified at the beginning of this little spiel actually take place. And as the agent of the court, you know, some people have said he's the referee, right? He gives the thumbs up or the thumbs down on whether or not the police department and the city are in compliance. And so some of you may know that in 2002, there was a prior consent decree. No. There was a prior Department of Justice investigation in the city of Cleveland. It never resulted in a consent decree. Folks often talk about it as if there was a prior consent decree. That's my blurb there, right? Instead, there were recommendations made by the Department of Justice related to police misconduct with the City of Cleveland Police Department at that time. And as a result of those recommendations, the city was perhaps maybe going to implement some of those reforms. We now know that those reforms weren't necessarily implemented and that other issues cropped up. But I often hear community people say, well, we've done this before, how is this gonna be different? It's different because in 2002, when those recommendations, when that investigation took place and then those subsequent recommendations came about, there was no monitor. There wasn't an official court case. There was no one checking in on the police department and then reporting back to the court to talk about how the changes or how the recommendations were being used. And so, you know, I think we're at a very different posture, fortunately and unfortunately, than we were in 2002. With that being said, I think now might be a good time, Attorney Nelson, if you could maybe talk a little bit about the Department of Justice's investigation for this current consent decree.
Well, first of all, thank you for hosting this event tonight. And it's as I look around, I see Judy Lipton, and you know, Judy Lipton was one of my professors.
She's like, thank you.
She probably didn't want me to tell you all that. She was fresh out of law school. And I see my insurance man up there, and some other colleagues and other friends. You know, the Cleveland falling under the jurisdiction of the Department of Justice is the result of individuals who were very active in and concerned about the abuses that citizens were suffering at the hands of a police department that was out of control. I remember one young lady, she now works for the city, who called the police because her son was having an emotional issue. And when the police arrived, well, she had talked to one of the agencies, and she was assured by the agency that they would send police officers that had training in mental health. Well, when the police officers arrived, the young lady was standing in the door prepared to greet them, to direct them to her son. Instead of them asking about the son, they jumped on the young lady, slammed her to the ground, stepped in her stomach, and then while a neighbor says, "That's not the one, it's the son, it's the son." And they immediately then diverted their attention from stomping on this woman to going, and they gently walked the son out to the vehicle. While another son was tending to his mother, they then came and jumped on the son that was attending to the mother. So it was these kinds of events. And then, of course, the infamous out-of-control police chase into East Cleveland, where James Hardaway, who at that time was one of the chairpersons of the Legal Redress Committee of the NAACP, went to the leadership and said, okay, enough is enough. He then sat down with other organizational leaders and prepared a letter. After much discussion, he finally got to the point where he didn't want to have any more discussion and just wrote the letter and then added the other individuals' names to the letter and gave them the challenge if their names wanted to come off the letter, they could take it off. But he was sending a letter to the Department of Justice, which he did, which resulted in the in this consent decree that now has been established and agreed to by all the parties. The problem was that in discussions with the police department and with the city's administration, there was more denial than there was acknowledgement that we were having a problem. Of course, you heard the infamous phrase, we have a problem, we know we have a problem, we just don't know what to do with the problem, and on ad infinitum. Well, the leadership of the NAACP at that time was also reluctant, and Attorney Hardaway actually drugged them to the table and just put their names on it and said, we're going to do this. And if it's your position that we shouldn't do it, you would publicly stand up and say, well, we shouldn't do this. That's the position and sometimes you have to do that in order to get things done. Sometimes you as a leader have to take charge of a situation and actually take that and just run with it and literally drag people along. And that's been our experience in the city of Cleveland. Were it not for the reluctance of the administration and others to actually become engaged, we might still be talking about the need for a consent decree. But the fact of the matter is that organizations and individuals, Dr. Rhonda and others, who all came together, collaborated on and supported that letter to the Department of Justice, resulted in the department actually coming to town. Now, before we actually got to the consent decree, there were numerous discussions around town. I remember the first one was at the offices of the Metropolitan Housing Authority over on Kinsman. And at that time, we actually took testimony with Steve Dottlebuck and other individuals from the Department of Justice there, and they had people actually come and tell their stories at the Housing Authority, and that became part of the baseline. And when the investigation was in its process of being developed, and the decree was being written, some of the background information included many of the testimonies from individuals who actually came forward that day and made known their issues and concerns. So now where we are is, has been reported, we're in our enforceable decree. And ironically, in the state of Ohio, this particular, as has been discussed earlier, the first consent decree was not the first type of decree that's been agreed to by the Justice Department that had no enforcement power. The famous federal, United States Supreme Court Judge Clarence Thomas actually came into Ohio when he was with the Department of Education, Department of Civil Rights, and actually wrote a consent decree that no one ever signed off on involving Central State University, where they found that there was significant discrimination in funding. So it's not unusual that we have these unenforceable, unsigned sort of agreements goodwill agreements, where discrimination, or in this case, abuse, was actually identified and discovered, but did not result in any real enforcement action.
Okay, thank you. So we framed just the history, the background of what has happened before in prior instances with the Department of Justice and the current consent decree as a way to sort of frame how lawyers, how you can work together to bring about change, to get the government to actually begin to enforce needed change. And so I want to turn the discussion now to particularly how do you think the consent decree or the things that we're doing in police reform will actually address the concerns of some of your clients. So whether that's the NAACP, whether that's the mentally ill, whether that's the LGBT communities, or all groups. And so let me turn it over to you, Dan, and you can speak about how do you think this current process of reform will actually improve things for your clients.
I represented Edward Henderson, who was a mentally ill person who, on January 1st, 2011, led the police on a chase. And it started out around 72nd and Chester, in this neighborhood, and wound up going all the way downtown. And once they crossed 55th Street, the 5th District Police were under orders from their sergeant to stop the chase. Cleveland Police had a policy in place that if it was too dangerous to be chasing somebody through the city streets in traffic and pedestrians and other people, they should stop it. And under all circumstances, or under any circumstances, there should only be 2 police cars involved in any chase. Nobody going parallel, just 2 cars following. Because of problems with communications with Cleveland Police, the police on the west side of 55th Street didn't get the word. They were working for a different sergeant, so they continued the chase. And they chased him, sometimes coming forward into him, and sometimes not. They chased him over to the Shoreway at East 9th Street. He got on the Shoreway going the wrong direction, all the while being followed by a helicopter telling him, back off, guys, I'll follow him, et cetera, et cetera. It didn't come out in the paper that 3 Cleveland police cars followed him onto the freeway, going the wrong direction, and chased him for a statute mile in the wrong direction. By this time, they're very angry. Henderson stops his car. He's sitting on a guardrail down near the Cleveland Police stables. And 2 Cleveland police officers that were getting gas next to the stables kind of tripped over him and arrested him and handcuffed him. Well, the 6 officers in the 3 cars that were going the wrong way on the freeway charged across the freeway and kicked him many, many times to the point where his eyeball nearly got knocked out of his head. And it was all recorded on video. Video which was suppressed by the courts in 2 different cases, and eventually it came out. So that became the focus was, oh, it's the policy, the pursuit policy is the problem. We don't have a correct pursuit policy. So they pretty much told him to quit doing that. And then about a year later, was it a year and a half later? About a year. The same police department, responding to a backfire from a car down near the police justice center, thought it was a young police officer who didn't know that old cars backfire and didn't know what a backfire was and thought someone was shooting at him, so he announced that someone was shooting at him. And the car went across the river, picked up the 2nd District Police, and came back across town, and 63 cars were involved in that pursuit, where the policy is only 2 cars. 63 cars, 1/3 of the force on duty that night went a little rogue, and it wound up killing 2 mentally ill people. And I'm sure you've read in the papers. So then the Justice Department intervened and said, they'd been talking a long time, but my experience is it's difficult to determine where the total incompetence leaves off and the maliciousness picks up with the Cleveland Police. It's just hard to tell. They're poorly trained, poorly equipped. They have limited education. There's nobody in the department that has an advanced degree in law enforcement, even though those institutions are available in this state. It's really, really difficult. But there's some structural things that the department can do to change some of this. They could change the education requirements for their recruits, which will at least get them older, more mature recruits. I focus on mentally ill people because, let me put it this way. In 2002, you were referring to Then Chief McGrath got a letter from the Justice Department outlining what it was that he could do to make for a better police department. And one of the things was to start collecting data on use of force and other data like tardiness and different data that would raise flags that we know from other experience will raise flags and say that maybe this officer has a problem. Maybe this officer we should address that. But first you have to collect the data. So in 2004, then Chief McGrath agreed again to start collecting the data. And in the course of discovery in the Henderson case that happened in 2011, there was no data. As a matter of fact, in Henderson's case, there was never a use of force report made. It didn't go down as nobody had injured this man at all. The story was he had crashed his car and was injured in a car crash. In 2015, Safety Director McGrath, same man, thanked the Justice Department for providing the city with the software that they could use to collect the data, that same data that hasn't been collected since 2002, and I'm not sure if they're even collecting it now. They don't know what's going on in their own department, and they can't correct anything without knowing what's going on. So there's some structural issues with the department, there's political issues, the fact that the last 3 chiefs of police never achieved the rank above sergeant on a civil service exam, except for Flask. He was a lieutenant for a couple of weeks before he became chief. The commanders in the districts are appointed by the mayor, and they're political guys, and they don't have to have a particular rank, and they do community relations work and keep the populace placated. They're the ones making the calls. They're not necessarily police people. And the victims in this, I'll make my last point, I'm sure you've all seen video on the internet over and over and over and over again about people being abused all over the country. The only thing that's really different in my 30-odd years of practice is the cameras. That's the only thing that's different, is it's the cameras. And the people being victimized are poor people and mentally ill people and people without power. And just to illustrate that for a second, everybody other than a student or faculty at Case that lives in the city, you raise your hand? Well, there's not many of us here at this discussion. So it's not very empowering and the other thing is that everything from the Henderson case to Tamir Rice to the 137 shots, here's a structural problem that they have. When the event happens, the police are represented by the law department. The law department is also in charge of disciplining the police. They represent the chief who's in charge of discipline. They also have to settle the civil claims. So they have a natural conflict of interest. And sometimes our police officers get a little too much help from the law department about what the facts are in a particular case and what the strategies are for defense. So they just can't discipline themselves in the current structure, because eventually they're going to have to write the check to the families of the people that were abused.
Okay, so thank you. I just want to highlight that very interesting, and again, to highlight the point about lawyers and the need for lawyers, right? The whole point is we put in policies, we're supposed to make sure that they're followed, and the breakdown, not only in the police system, right, very much in the political process, in the healthcare realm, that there are no checks and balances. Let me turn it to you, Maya. I'll make sure I turn on the mic.
I got it.
Good evening, everyone. I wanted to start off by saying what it is exactly is done at the two institutions wherein I work. So Nueva Luz is a community resource center that's located on the west side of Cleveland, and it provides case management and legal services to those who have HIV and AIDS who live under the federal poverty level. So what that means is anytime someone has a legal issue that, as identified by lawyers or case managers, we work to provide free legal representation, often and only actually in the realm of civil litigation. However, whenever there are criminal issues that come up, we try to find a pro bono attorney who would assist in helping the client out. So what we see, generally speaking, is all of the clients there are under the federal poverty level and receiving case management services. We have a lot of intersections of poverty, of substance abuse, of mental health issues, as well as medical issues, generally speaking. So when we have someone who's looking for legal representation, we're seeing a lot of the issues that are inherent in the neighborhoods that they're experiencing and they're living in, and how they are treated. We are seeing a lot of discrimination across the board, and we are the first-hand responders for a lot of instances of issues with the police. So evictions come to mind, problems with landlords, problems with police in terms of handling and responding to domestic violence and intimate partner violence claims. Those are just some of the examples of how we see and what we see in terms of cases. At the LGBT Center, we are oftentimes the first responders for individuals looking for referrals and resources, or looking for help when they have been victimized by the system at large, as they report it. So for example, someone feeling that they were discriminated against as a result of perceived or actual gender identity or sexual orientation, they will come to us looking for the way in which to remedy the situation that they are in. We often get reports as well of perceived police brutality and just claims for or assistance for asking for help. Someone that would understand me, someone that will make me feel comfortable, someone that's going to make sure that I'm okay and not re-victimized after this process. Based on what we've seen in this experiences, both at Nueva Luz and at the LGBT Center, some common themes had come to be in terms of where the needs and areas were that we needed some assistance in. In general, when this police consent had first come across, we said, let's make sure what we're seeing at these agencies is actually what the population wants. And so we had several forums from the LGBT community, and we said, what is it you're having problems with, and what is it you're looking to resolve? And based on that, we're hoping that the bias-free policing and the remedy of the consent decree is going to do some of the following things that was a result of the survey process as well as the forums that were held. So some of the things that were requested by the community at large were items such as an LGBT liaison for the community to go to and be able to talk to when they had an instance in the community that made them feel victimized. They were looking for sensitivity training across the board. So every time there was an in-house service or an in-house training of the police force, to make sure that we are addressing issues of LGBT competency with the specificity of transgender competency, so that we are able to appropriately expect all members of the police force to know how to do such things as use appropriate gender pronouns when addressing someone, or taking the time to stop and ask how someone would feel comfortable being addressed. How do you use intake forms? What does it look like when you're doing a call for domestic violence? All of those procedures and protocols that add requirements of a little bit more heightened sensitivity were things that the community was asking for time and time again. A couple other things that came to mind were the recruitment of LGBT individuals into the police force so that, again, there was more of an understanding of what was happening and that there was representation on the police force. And lastly, I think in terms of the ability to report issues where someone was feeling discriminated against or was feeling that they weren't being heard, how is that reporting process and procedure done? And is it easy to get to? We have seen that reports and FOIA requests have shown that when it comes to LGBT specific indicators, there's only a handful that are actually showing up for the police, although we're having many coming in to our doors that are saying, this is an instance when I felt that I went to the police and they didn't respond to me appropriately, or they didn't give me the advice I needed, or they left me and my case never got handled. And if they're being able to tell that to a community agency, but they don't feel the need or the ability, to go and report it elsewhere, it's not going to be remedied. So those were some of the things that I wanted to report back that the community had asked for. And I think some of the items that we believe that we're hoping that the consent decree and the bias-free policing will be able to help to address from the LGBT side.
Okay, thank you for that, because that gives us an idea about why understanding and respecting difference really matters. I want to turn it over to Mike just to talk about the consent decree. How does it address the concerns of the people you represent as the president of the NAACP? And then you can also begin to talk about why you think why the respect for difference matters.
You know, how many of you get pedicures and manicures? Raise your hand. If you get a pedicure, just don't be ashamed, raise your hand. Hold them up there. Hold them up. I saw about, okay. The person that does your pedicure and manicure has 3 times the training of your Cleveland police officer. Is that right, Dr. Rhonda? It's about 2 or 3 times. The police officer's training is about 400, 500 hours. The person to become qualified to do nails and feet is about 1,100 hours of training. That's what they require before you can to do pedicures and manicures. In the past, a police officer is typically a person who came out to service, was an athlete, whether it's a male or female, either the macho guy or the aggressive woman, and they had to deal with a limited number of issues. The person being bad, they didn't have much training with disabilities, hearing, vision, language issues, mental health issues. They just, you ran the red light, you robbed the bank, you had a fight with your husband and your wife, you stole somebody's bicycle. But the need now is much broader than that. I understand we have about 140 ethnic groups in this community in greater Cleveland now. So the training and the exposure has to be much broader, and the police officer, maybe they need to be in law school for 3 years and getting getting the kind of, not only the physical training, how to shoot and clean your Glock, but also how to deal with the myriad of problems that are now present in a community that has the issues we have. When you have a graduation rate in your largest municipal school district, and it's like 60%, that means, or less, that means you have some serious educational deficiencies that you as a police officer are going to have to deal with. Judgment issues because of that lack of education. When you have the kind of family issues that are present in this county, it means that you as a police officer have to be much sharper than you were when you was just one of the old boys, old girls. And to see, now as we talk about bias-free policing, notice we did not use the word racial issues, because in bias-free policing, it addresses the issue that you may have a person that is LGBT on your police force who may have no sympathy for others in that category. Or you may have African American police officers who may crack your head with the same kind of efficiency and repetitiveness that a white police officer would crack your head. So it's not only about the ethnic groups on the police force, but it's about the sensitivity, the training, the preparation, and the oversight of other officers. The type of issues we get at the NAACP are typical of those that go before the so-called Civilian Review Board. They had 4,000 plus taser reports, which is probably half of what they really had, and not one finding of a taser that was improperly used. The taser was used 4,000 times against citizens, and not once is there an indication of one where it was improperly used. Now that is illogical and improbable and highly impossible that you could have that kind of those types of incidents. And then we have to look at the issue that there's a mentality in the police department about I protect you, you protect me. We look at the Arthur Fechner thing where the drugs were dumped in the community and nobody went to jail except the people that were using the drugs. But the providers of the drugs, Gerald, the providers of the drugs, Doug, didn't go to jail. They got promoted. One of them is in this. You just talked about him. He used to be the safety director. Now he has a special job now.
Oh, Mr. Flask.
Yeah, you said his name. And the other one was a police chief. So we have these kinds of issues that we are confronting.
Which conduct was upheld by the Ohio Supreme Court.
So that's what we're dealing with when we talk about police. And you talk about the personnel files. Dr. Rhonda in her position and the monitors in their position are trying. I think there's a requirement now that police files be held open a little longer. You all working on that and fighting the union on that issue. Because a police officer that cracked your head 10 years ago, that's wiped out of his file as a fact. Whatever the time is, it's a short period of time. So he can crack your head, then go crack yours. They look at his file and say, well, he never cracked anybody's head before. And if he waits another 3 years, sure, he can crack you upside your head, and no one will know he cracked these two people upside their head. So these are the kinds of issues that we have to look at, because what it allows, if we don't correct them, is it allows this culture to build. There's so many other things we could talk about that need to be addressed, and fortunately, under the consent decree, and there's another issue too, because if we don't have monitors and members of the commission who are committed to resolving the issues and committed to the committee. We have one police officer who said the whole thing's a sham, and he's a member of the commission. And he says this thing is just a bunch of garbage, don't mean a thing. So we have to make sure that people on the commissions and on the committees are actually committed to the proposition that they signed up for. Now, how does that happen? Number one, we have to have meetings like this where there's critical mass. So when people get the information, they become part of the process. So if someone does not do what they're supposed to do, then when you go to the ballot box, you can do what just occurred with respect to the prosecutor's office. You can hit the right check, hit the right dark in the right circle, so that's your ability to hire and fire people. That's your ability, that is how you fire people. The two individuals that Dan talked about that are now leading the police department, not the chief, but the other two, are individuals who, number one, the mayor could fire in a heartbeat, but he has not fired them. He, in fact, gave them promotions. In one instance, gave one a $20,000 raise after the 52-car, 62-car.
They're both retired and double dipping.
So those are the kinds of issues. I'm going to yield, but I want to make sure you know that these are the kinds of things that we hear about at the NAACP and need attention, but you have to be part of the checks and balances by using your strength at the ballot box.
Okay, so we're going to wrap up and open it for questions, but I just want to say thank you to the panel, and particularly the last discussion about how there's been a change and why it is so important for us to respect differences when interacting with people. Before, as you said, it was just about sort of applying the law, but when we have differences here, whether it be challenges about hearing, seeing, mentally ill, LGBT, development, developmental issues, that these are issues that the police officers have to be trained in, but that we as lawyers need to do the work to ensure that our clients, if they're suffering from these differences, that their rights are respected. Furthermore, I would just like to say that to the lawyers, I have lots of law students in the audience, but to those practicing too, I think one of the things that is quite clear is that we cannot have a change, whether it be police reform or in this country, of protecting the rights of the poor, the disenfranchised, if the rule of law does not mean anything. That we actually have to uphold the rule of law to punish those who are doing wrong, particularly in instances where they act in a biased way and fail to respect difference. So let me close the panel and open it for questions.
It seems to me that if you live in Cleveland, work in Cleveland, or even care about Cleveland, and you're not concerned about this, you'd have to be a piece of wood. I have two questions that I'd like any of you to respond to. The first is, are you satisfied that the consent decree identifies fully the issues that need to be addressed and the goals that need to be achieved? That's the first question. The second question is, are you satisfied that the consent decree now in place has satisfactory enforcement mechanisms to achieve the goals identified?
I'll defer on that question.
I'll start off. I do know that one of the problems in this consent decree was the hastiness with which it was finalized. I believe there was, on the day that Judge Oliver decided it was a appropriate and acceptable, Dr. Rhonda and James Hardiman and some other community folks were at the courthouse waiting for the opportunity for additional community input. That opportunity did not come, and I don't think it has come yet. Now, I'm not talking about working through the monitors. I'm talking about before the agreement was journalized by Judge Oliver. And there should have been more time and opportunity for community involvement. I mean, there was even discussions about filing amicus, and the court told them, no, thank you. So I don't know what the hastiness was. I don't know if it was because we got this convention coming or because there was some political considerations there or what. But there needed to have been more community involvement so that there could be greater checks and balances, and that did not happen.
No, not satisfied that it covers what needs to be covered. The consent decree comes by a federal statute, very limited scope that gives the Justice Department jurisdiction to protect U.S. citizens in American cities from having their civil rights violated by the police. All right, so that's the limited portion that this is all about. It doesn't go into incompetence or all the other complications that come out of all the other problems that the city has. What were you just saying, Michael?
Yeah, but only two parties to this.
Oh.
Two parties to that's the other problem.
The city, I'm a cynic, and I've been watching them pretty closely, but the elected officials, since I graduated high school and moved to the city, have had little or no control over the rank and file of the police department. And they just sort of defer and let it go and let it go and let it go. And now here we are. This has just been a neglected department for generations. And, it's going to take a long time. It really wouldn't take that much time if the rank and file had leadership and were enthusiastic about improving. They could become first rate. But there are institutional issues, some having to do with the union contract, and here's one of them. For instance, you're talking about If, as Michael said, you get hit on the head by the police officer and you're unhappy about having been hit on the head, and you want to complain about being hit on the head, well, you can file a paper and complain about the police conduct with the Civilian Review Board. The Civilian Review Board doesn't see it. It goes to another police department for investigation. And this is part of what the consent decree is going to change. And then that department reports to the Civil Review Board. And there hasn't been a single instance of misconduct that I can recall since Judge Voinovich set up the Civilian Review Board. Another thing is, if you are hit on the head by the police officer, you are more than likely to be a defendant in court for having done something, whatever it was you may have been accused of. You're a defendant. So that case that you have needs time to resolve. Meantime, if there's no letter of complaint made within 90 days of the incident per contract, they can receive the letter, investigate the letter, but no action can be taken against the police officer if the letter is more than 90 days old. That's an institutional problem.
Let me make one final comment on this. It'll be a quick comment. I said it, and you may have missed it. There were only two parties to this consent decree, the City of Cleveland and the Department of Justice. We wanted to have third parties, which would be community organizations, whether it was the NAACP or some coalition of organizations, but we couldn't get that. The judge was not open to a filing of such nature. So that's the other limitation on this decree.
Okay, we have time for 2 more questions, so yeah.
Okay, I live in Cleveland and I work in Cleveland, and when all this came about with the consent decree, I felt that it rested squarely on the shoulders of the mayor and council, because I believe that that's who, I mean, I pay tax dollars, I own a house, I work, and I believe that there's the captains of the ship here, and everything, if they're lackadaisical, and we're going back to 2002, I don't know who the mayor was then, I'm trying to think, maybe it was Jane Campbell. Okay, well, maybe the one thing that the group needs to look at is to get somebody who has some chops, to run for mayor, who's really interested and committed in this issue, because I agree. I think that this issue needs to be addressed, and you need somebody with some chops who's going to take it on and tackle the problem. And the other thing I wanted to point out, that the victims just aren't the mentally ill and the abused people, but the ordinary people like myself who pay taxes, who live in Cleveland, who have to live under this, atmosphere of what's going on. And I think you also need to look into the Metro Park Police, because I myself witnessed an instance of severe abuse of a mentally ill young person by the Metro Park Police last week. It was ridiculous. And they came from Edgewater, or the kid happened to be down at Edgewater, and I live in Detroit Shoreway, and he ran up to Detroit Shoreway, but it was really like over the top, and I saw the whole thing. And I think they need to be brought into this too, because I think that they're just, they're abusing their powers as well. So that's all I have to say.
Okay, thank you. We'll take.
Yeah, so I don't want to load this question up, but I conducted combat missions in Iraq, and one of the things that I noticed there was that there was this perception prior to going there. You had the people that had already been to Iraq, and they had a negative perception about the people of Iraq and just the country as a whole. And even being there was sort of this, you develop this disposition towards the people, and so you kind of categorize all of these people as being bad. And so I'm wondering, in the police department, is this being addressed where, on TV, when you turn on the TV, you can clearly see that they're highlighting East Cleveland as a bad area just as much as the south side of Chicago or the west side of Detroit. So how much is this talked about in regards to the sort of perceptions that these officers start to develop from, I guess more so from an institutional standpoint?
they call them the Army of Occupation amongst themselves. They refer to themselves as an Army of Occupation.
You know, the difficult, we recognize that policing is difficult. I mean, you are a police officer because you are there to protect and serve. The issue is that in some instances, and it could be because of preconceived notions, it could be because they had a bad day, wife wasn't kind to him, or husband wasn't kind to the wife, or whatever the circumstance may be. The kid may have been loud, kept him up all night. The fact of the matter is that they can't afford to make the kind of misjudgments they make because it affects too many people. It's like a pilot who decides, well, I'm tired of this, I'm just gonna crash the plane, okay? So that is why we're talking about you must increase the education, you must expose them to de-escalation. There needs to be discussion about recruitment and retention, mental health reviews after like you just said, when you're in the combat zone, you have to step back for a minute. So the same kind of, as we look at bias-free policing and looking at the consent decree, there are other things in the consent decree to talk about how to address the mental health of police officers as well.
And there's also a charter amendment that is a part of the consent decree that City Council is supposed to put on the ballot in November. We're slated as a part of institutionalizing bias-free policing as an ordinance for the city of Cleveland where the officers are under law not allowed to police in a biased manner. What that means, because we all have implicit bias, right, means that there has to be an enormous amount of training to counter those biases where we categorize certain people as bad people, right? Yeah.
All right, so I'd like to thank you for coming. We are going to end the session, and I welcome you to join us at the reception right after. But thank you so much for coming.
I want to send you.